If you own your own business, there's a really good chance your lawyer is costing you way more money than you thought. Most business owners call their attorney when something goes wrong. That's not where we want to be. That's not the highest and best use of an attorney. We started Venerable Business Law in 2018 because I had litigated for a number of years and seen endless amounts of problems costing tens of thousands of hundreds of thousands of dollars that could have been solved with maybe a few $1,000s up front and good legal planning. The reaction idea of only calling a lawyer, especially a business lawyer, when things go wrong, it's just fundamentally flawed. A good lawyer is going to proactively work for their client and protect them and make them better come some sort of harm, some sort of liability event. And really the best and highest use of a business attorney is keeping you out of those problems that would otherwise arise. The very difficult thing, I think, in the legal profession and when business owners hire lawyers is that there is a friction-prone process. What do I mean by that? I mean that typically it's a $5,000 to $10,000 retainer. Typically we call up and say, can you help me with this? The lawyer says, yes, send me the retainer on a deposit and I will explain to you all the things that I can do for you. We here at Venerable Business Law, and me myself personally, I actually take it the exact opposite, right? So we do everything on a flat fee or subscription. What does that mean? It means that we have to spend a considerable amount of time understanding the scope of work that we are getting into. Yes, of course, some things are a little bit easier to just walk into, but we have to spend some time trying to figure out how to solve your problem before we can really scope out and tell you the exact price, whether it's flat fee or subscription. I'm going to walk you through 10 things your business lawyer should be doing for you right now. And by the end of this video, you'll know exactly what proactive legal protection looks like, the questions to ask your current lawyer, and the red flags that tell you it's time to find a new one. Whether it's us or somebody else, if you are a business owner, if you are a CEO, if you are the founding member, if you are a relatively small board, your relationship with your business lawyer is a very important one. Whether you're running a small business, scaling a company, or about to sign your first big contract, these 10 things could save you 6 figures, maybe even more, in legal fees, lawsuits, and deals gone wrong. All right, so here's number one, folks. Review your contracts before you sign them. Sounds pretty basic, right? Quite often, I find that lawyers just make many assumptions, right? So we assume that the clients have reviewed the business terms, they understand the business terms, or they had a conversation with somebody and said, this is what the price is going to be, this is how we're going to get paid. Send it to the lawyer, hey, Mr. Lawyer, does this look right to you? And really, more often than not, what that lawyer is doing is looking at it from a legal perspective. Is this a good or bad contract by legal standards? Now, we go the next route. We actually have our clients fill out a separate form to tell us the importance of the deal, the monetary value of the deal, what's the expedited nature of the deal, what is the strategic advantage at play here? Is this something that we are dealing with a really big player and we need to make sure that we understand the economies of scale here, what we're dealing with. If we're dealing with a publicly traded company, we're probably not going to be able to negotiate the best of contracts, and our client really needs this thing like life's blood. So we have to really understand the context of the deal, but really make sure you are reviewing these contracts. Most common, very easy things we see are auto renewals, meaning you're automatically sucked into this thing for 5, 10 years, I don't know what it is, for no real apparent purpose. And I argue these things all the times with my own vendors because really what's the added advantage? Unless and until you've really given me some sort of added benefit. Maybe you've given me better pricing. Maybe you've given me a tremendous advantage because we signed up for 3 years. Yeah, that could potentially be enforceable, but just because you've done a normal contract and you put it on auto renewal does not necessarily make it enforceable, and you should certainly know what you're getting into when you're doing that. Another point we look at quite often is indemnification. Literally, I had the question with a client yesterday, what does this really mean and how does it work? Indemnification means that if the other party gets sued or comes into some sort of liability event, you are required to indemnify them or make them whole or defend them in the lawsuit. And that's unavoidable at times, right? If we're selling someone else's product, if we're doing things related and some of my conduct or conduct from my people causes someone to get sued, by all means, we should be indemnifying them. But it shouldn't be unlimited, and it should be limited to the reasonable scope of what we did And also, we should have the ability to control that. The way a lot of indemnification provisions are written is that it's just wide open. You just have to indemnify us, meaning they get to spend whatever they want during the litigation. And if they come back with a $500,000 bill, you just have to pay it because that's your indemnification. So a lot of times we try to do work on limiting the amount of indemnification, meaning the amount of damages that you would have to pay by indemnification, and also having control of that process, getting the right to appoint our own counsel, the right to actually have a say in that proceeding rather than just waiting until all things go wrong because the other party figured someone else was paying the bill, so they didn't really care. Another one that I came across recently that was quite surprising to me was personal guarantees. Personal guarantees are going to be necessary for a lot of people to sign, but they don't necessarily know what they're getting into. If you are a brand new company with zero credit and zero assets, by all means, anyone that's lending you money or leasing you a space or leasing you equipment is going to want the individuals behind the company to sign a personal guarantee, meaning that the company's not only on the hook, but the individuals are on the hook, right? That is a liability for you, and you have to make sure you understand how does that affect your other assets. In Florida, your personal residence is not at harm because we have some of the strongest homestead protections in the country, but in many other states, there are some issues with that. And so you could be risking your personal residence, you could be risking your vehicles, you could be risking money in accounts if that deal goes bad. So just understand what that personal guarantee is and what you're getting into. It's not necessarily avoidable, but it could be limitable. It could be subject to some reasonable limits. Oftentimes on commercial leases, what we are doing is making it a rolling guarantee, meaning year by year. So the max personal liability you get there is 1 year, 2 years, or maybe after the business is out of startup phase, the first 2 or 3 years, the personal guarantee burns off altogether. Those are things to look at and just understand that I find a lot of business attorneys are just not giving that advice to people. So make sure you're looking at those things as well. You should be really taking a look at your business structure. So number 2 would be auditing your business structure every year. This is one of the things that I find extremely problematic for a lot of folks, and I see it all the time. They went into business with a couple partners 10, 15 years ago. They never really signed any of the agreements. They've never abided by any of the agreements. Even what's in effect really doesn't apply to how they run their business. You really should be taking a look at that structure. You should be updating it. Partners have come and gone. Directors have come and gone. Officers have come and gone. The way we sell product has come and gone. Maybe we're selling a whole nother product. We're building a whole nother thing. And we still have documents from 15 years ago that really don't reflect anything at all about what we're doing. And these are kind of situations, folks, they're not a problem until they are a problem. But there's pretty easy steps just by easy updates. And I say an annual audit is a very easy way to get at that. So I would definitely make sure you're taking a look at that. Liability exposure is going to grow as the business grows. We constantly use the term or the terminology, what you got you here is not going to get you there, right? So we have to make sure that we're looking at those things. We always, as we are building an asset, as we are building a business, should be looking at it from the perspective of tax planning and asset protection. There are many different options of adding in holding companies and management companies and leasing companies and ways to offset certain liability. And we find more often than not, people have all of their assets sitting in one bundle. And if there is a liability event, all of their eggs are in one basket. So number 3 for you folks is protecting your intellectual property. What is intellectual property? It's the stuff that you are building alongside your business. It's the intellectual material. It's the trademarks, the copyrights, the branding, the patents, the stuff that the know-how, the trade secrets and things like that. Far too often we see that I'll do it later kind of mentality. One of the most common trademark issues we see is someone goes and registers a company in the state of Florida and says, well, I reserve the name, so I should be okay. That's not the case at all, folks, right? And you may or may not have rights to that domain when someone's been using that company name in Idaho for 30 years and they're going to send you a cease and desist. Now, branding is not necessarily the biggest issue for a lot of companies. There are a lot of law firms called Smith & Associates. Pretty much anybody care less about that because it's really the relationships with the people. But if you're certainly building a brand, you want to actually know who actually owns the work and your contractors, employees create, right? So you want to make sure that as there working for you, you have protections for that and also against the outside world. If you have a worker that's been with you for 10, 15 years and then goes out and decides to create a competing brand, they may or may not be able to do that. However, you have to take a look at really what are your IP or intellectual property protections. The horror story is when you lose your brand. And I've seen this happen. We have nationally recognized brands and you start competing in areas that you never knew were possible. I'll give you one very specific instance, and this is not, I won't mention the client by name and I certainly won't mention the brand, but it was a local coffee roaster here out of the state of Florida, and they started selling all across the country, and they got cease and desist letters from about 3 different brands because they didn't own that trademark and certainly didn't have any intellectual property protection. So I'd really seriously take a look at that. So that's certainly number 3 on our list. Let's get to number 4. I look at this all the time, and number 4 is writing your own employment documents before you hire. Listen, in this day and age of AI, starter documents are certainly a thing. And I'm not here to tell you all AI documents or form documents you can find on the internet are bad. And maybe that's all you can afford, and maybe that's all that is reasonable for that set of circumstances. But at a certain point, you should have attorney-reviewed documents to understand the pitfalls that you might be in. AI and forms are only as good as the information that you feed it. And without being a lawyer and without seeing these things turn in a bad way, you're not necessarily going to know what things to protect against. The general person, the general business owner has no problem reading plain English, hopefully, right? Or their native language, I should say. And at the end of the day, it could be very straightforward what things are in there. But what about the things that are missing? What about the things that we've seen solve problems 9 times out of 10 and keep people out of litigation? Those are things that the average person has no way of knowing and could never inform AI, and AI would never know to tell you otherwise. So your offer letter, your handbooks, your non-competes, what's actually enforceable, what's not enforceable. You could be misclassifying contractors, 1099 versus employees, W-2s. You could end up with an IRS or Department of Labor investigation that could shut down your business. It's not just a problem for that one person. It could be a problem for everyone that's misclassified. When I said that one person could file a complaint, and then you end up with the Department of Labor investigating your entire workforce, and that could be a potential business killer for you. The one clause every employment agreement needs is to make sure you understand the rights and liabilities of that employee, what they are building, and make sure that this is an at-will contract, right? You have the right to get out of this. This is not where you are embedded and guaranteed to this contract for the next 3 years. So this person has guaranteed money, guaranteed severance, guaranteed whatever. You have to make sure that you understand. Listen, if you are making certain guarantees for someone, you can certainly do that, but make sure that you have an out along the way. Number 5 is, I think, probably one of the most important and one of the biggest things that we see lead into disputes is building your partnership or your operating agreement from the position of dissolution or breakup. We call it a business divorce for a reason, or we call it a business prenup for a reason. People get into business because they want to be in business together and they think it's all going to be fun and all together and we're going to get along great and we have a lot of great energy, but they're not asking the tough questions in the beginning. I have a situation right now where very early into the business, the first year, everything seemed great. They were going to need some marketing help from some individual, so they gave them a good portion of the company. Now that they're realizing that the 2 real business drivers are really doing all of the work, and that marketing help that they thought they needed like life's blood was not really that much. And in fact, they're carrying the bulk of the burden with that marketing help. So we need to really right size that agreement and get in there and do some adjustments, hopefully in an amicable way, because once people get embedded into certain percentages and believe they're owed certain things and they believe they're founders, it's very hard to right that ship. So what I always very strongly urge people is, rather than talking percentages, talk projections, right? If we're talking about $100,000 business versus $1 million business, those percentages mean a lot of different things. I think it's very endearing. It gives me a very warm feeling when people feel so gracious and so respectful of anyone that's lent them money to start a business and they were there in the beginning and they want to make sure that they're taken care of in the future. I think those are all good character traits to have. So just be frank up front, go through the hard issues up front. What does it look like if we are in a business divorce situation? And I say that it doesn't have to be an adversarial adversarial situation. It doesn't have to be we hate each other now, we're not agreeing. It could be a life change. It could be someone passes away. It could be someone has a spouse that has to move across the country and you can't be at that store at that location anymore and you physically can't do your job and you can't contribute to that partnership. So plan for these things in the beginning as best you can and ask the hard questions and make sure your attorney is taking you through that analysis. Here's the thing, most people just come to attorneys and say, we want a 50-50 deal, just give us a straight 50-50 deal. Well, a good business lawyer is going to ask you, well, what happens if you don't agree? We call that impasse or deadlock. So are there deadlock provisions in your operating agreement or your partnership agreement or your shareholder agreement? Is there ways to break that tie? Can we have someone else come in, an independent third party, and break that tie? Or are we just at an impasse and have to shut down and dissolve the company because we can't agree on anything? So every partnership dispute traces back to some sort of bad or missing agreement, right? That's at the end of the day, words that were not put in there, assumptions that were made, handshake deals. So if we concentrate on the front end, and this is not tens of thousands of dollars worth of legal work, I want to really convey this to people without you having to break the bank. I fully understand when I deal with startups that I am dealing with a budget. Everybody has a budget, whether it's $10,000, whether it's $100,000 or whatever. Nobody really wants to spend $100,000 on startup legal costs for a small startup, but sometimes that's the case depending on what type of business it is. But at the end of the day, there has to be value in that for you, and we value base our pricing too, right? Even though it might be a complicated agreement, if there's only $5,000 on the line, we have to adjust our pricing accordingly. So make sure you're looking at buy-sell provisions. What happens when a partner dies? Are you going to be dealing with the spouse, the children? Typically, people want to deal with the people they got into business with and not their spouses or their kids. Like, that's just the plain truth. Or some far distant cousin because they didn't have any relatives nearby. So make sure those provisions are protected for you going forward. You should make sure you're asking your lawyer all the tough questions. What does this look like? How do we split profits? Are we required to distribute proceeds at a certain time? Can we keep capital reserves? Make sure we have as much as possible in that agreement. Typically for an LLC, we'll always refer to that as a company agreement or an operating agreement. That's one of the most common formats we use in business. So make sure as much as possible is in there. Now, some of the day-to-day, you're going to have to document by different forms, but as far as the Bible, the end-all be-all, the model set of rules, you should really have that in there. Number 6 is what a really good lawyer can do, and this is really where we have focused in the last few years here at Venable Business Law, especially with our fractional general counsel programs, is keeping you compliant before there's a problem. A lot of people are reactionary. A lot of business owners are waiting till some bad problem arises, and they're really just going through the thing, living to the next thing, getting to the next dollar, getting to the next account, making sure that there's money coming in, and they don't really have someone looking over their shoulder to make sure that they're otherwise compliant. What does compliance mean? It can mean any number of things. It could mean licensing, it could mean employee issues, it could mean regulatory approval if you're in a regulated industry like a professional license, like a doctor, dentist, pharmacist, lawyer, of course, realtor. What are the things that you are doing? General contractors, there are all sorts of licensing requirements that you're supposed to keep up with and keep complying with. Are you doing that? And just because you've been in business for 10 years and have not had a problem yet, doesn't mean it's not going to be a problem. We hear that all the time. So really the best proactive legal services that we can provide is keeping you ahead of the curve. When I find time, when I know that we don't have 15 agreements coming at us from our general counsel clients, I'm constantly looking for ways to fix liability holes. Can we do some more risk management? Can we talk to the insurance carrier to make sure that all of the provisions that we think are in place are in place? I can tell you many times, folks, I've sat there and there's been a liability event when the broker had told our clients that there was a policy to cover it. And when all hit the fan, that's not exactly the way it worked out. So compliance review is a thing. One of the things that we are imposing now through AI models is contained AI models within companies to make sure that their contracts are compliant as well. So one of the deficiencies we see a lot of times is, as general counsel, even on a fractional basis, we're doing a lot of contracts for the business folks. The business folks inevitably will go get those contracts signed and they may or may not make them back to the lawyers, right? So what happens with that thing? Was it modified? Did someone make changes that we don't know about? So we're now making sure that all of those contracts are going back into one model And we have AI agents, closed AI agents for that company going back on a bi-weekly basis to make sure they're compliant with our set of parameters that we put in. These are things that we're building into companies and I think are only going to get better and more efficient and quite incredible protections that we can bring in. The other compliance that I see all the time that is ignored by a lot of businesses, and the laws are only getting stiffer on this. Privacy laws, data handling, website terms and conditions, privacy policies that comes without the terms of service. Most often those things are ignored until there's a problem. So make sure you're having someone take a look at those things and that you're up to date, especially if you're dealing with cross-border transactions. I know California has some pretty crazy restrictions, what you have to have on your website and what you have to have on your products that you're selling. So if you're doing business in foreign jurisdictions, meaning outside your current state of operations, make sure you understand the compliance that you have to go through. The answer that we hear all the time that's not a legal defense is, well, we've always done it this way and it hasn't been a problem. It's not a problem until it is. And just so you feel better about that, that is not a you problem. That is not a small business problem. And my answer would be, okay, wait till it is, because when it is, it's going to be huge. So why not try to fix it now? Why not try to get ahead of the curve? Much easier to do with a small business when you're only dealing with one or two owners or a small board or things like that. When you're dealing with these ginormous companies, it's like trying to move a cruise ship with a little tugboat. So it's pretty hard to get done. So in any event, I always say, make sure you're looking at compliance ahead of time before there's an issue. Number 7 on the list. This is one that I find particularly poignant and very important as a former litigator. So this is setting up a paper trail before you ever have to go to court. I litigated for 22 years of my career, and I hope for business owners you never have to get there. But if you do, make sure that all of your stuff is documented. When we are representing a client, either in a minor dispute, major dispute, kind of halfway dispute, we're always writing letters and documenting as if it was going to court, as if we had to show it to a judge, as if we were creating a record, if you will. But really what we are doing is creating an evidentiary trail. And from day one, we are crafting our narrative. If I was any form of successful in my white collar days doing white collar defense and doing white collar investigations without doing anything unethical whatsoever, is we were always building a narrative, building a story. So people tend to think everything in the court is black and white. Judges and juries are people too. So crafting that story, crafting that narrative, and making sure your documents are in line and the record is consistent and you're painting the picture that truly happened and not just trying to recreate it 2 years later. I have a client right now that's going through a pretty hot and heavy dispute with a former business partner. And I told her, and this is something that I took and borrowed from the family law practice area, document everything that's going on in a journal on a daily basis. There is actually an evidentiary theory that allows for contemporaneous notes written pretty timely to the event, to become evidence itself. Create a journal, create a log, create a record of what is going on, because oftentimes these things don't come to trial till 5, 6, 10 years later and nobody has a memory of what happened specifically. And it's really the facts, the details that matter. So make sure you're looking at that. Document everything that you think you can. If you have a strong documentation habit, that's going to very much help you win your lawsuit if it ever comes to that. Making sure that you're actually putting corporate records together, meeting minutes. What people don't think, if you don't truly have your corporation, your LLC set up the way you should, and you're running it like your personal piggy bank, you are certainly at risk for piercing the corporate veil. I think that one of the biggest misunderstandings that people have is that I can go on the Secretary of State and just register this thing and never do another thing, and I'm 100% protected. I'll tell you exactly an example of why that's not the case and how someone was very much harmed by this. I got a call a few years ago by a gentleman that had been running a very successful real estate appraisal company, and he came under fire from one of his underlings, from one of his junior appraisers, for really messing up a valuation on 2 different deals and costing the client several millions of dollars. And it was a really nasty lawsuit. And the guy had never set his company up right, had never had any really formal documentation to support the way the company was set up, other than articles that were formed and registered, no shareholder agreement. In fact, never even had a business bank account for his business, but certainly was the case. And he lost his entire business through that lawsuit. By the time I met him, it was a few years after all of that. And he definitely wanted to get things set up right the next time around. and make sure he was not going through that. A very simple step. I think if people had easier access to lawyers and understood the process and it wasn't such an intimidating process, that they could get really good things done for their business in really cost-effective ways, and everybody would be better for it. The lawyers would make a little bit of money, the businesses would be better protected, and you'd have an ongoing trusted partner as you're running your business. As I tapped into before, number 8 is reviewing your insurance policy before things go wrong. I have a lot of friends, a lot of referral partners that are insurance brokers and agents, right? They're not bad people. They're also not the people that are going to be there when the stuff hits the fan. So they're telling you certain things, and not every broker and agent is made the same. Not all of them know exactly what they are talking about. Not all of them can really interpret the legal language of what they are dealing with. And let's take the focus off of the insurance agents and the brokers for a minute. You very much, more often than not, as a business owner, pay very little attention to what the insurance actually covers and does not cover. It is a necessary evil for most business owners. They go, I'm just going to go get a policy for general liability, for errors and omissions, for malpractice, whatever it may be. I got this thing, I'm paying this premium, I have no idea. I mean, look at even like residential policies here in the state of Florida a couple years ago. People had no idea when the hurricanes and flooding came in one of the worst ways, the 100-year storm that hit Tampa Bay a few years ago. They had absolutely no idea what they had for coverage, me included. And I'm a lawyer. That's a problem, right? So review those policies, get with someone that can handle risk management that's not a broker or that's not your broker trying to sell you another policy. Get with somebody that understands all of these things. Get an independent consultant to evaluate your policies, your risk profile. What more insurance could you have to fill the holes? Should you have errors and omissions insurance, what we call malpractice as attorneys? Should we have any sort of policy to cover general liability if somebody walks onto our premises? Should we have EPLI, which is in relation to employment claims and things like that? There are all sorts of different levels of insurance. Umbrella policies are a great one. Your lawyer and your consultant on risk management and your insurance broker should be talking. We should be all on the same page. We should understand what these things are before there is a liability event, because by the time that happens, it's too late. Either we have coverage or we don't. And for sure, what we can all say is insurance companies love accepting all their premium payments, but they're not so great at paying claims. So let's make sure that we have our ducks in a row before we get to a liability event. We've seen real serious problems where people thought they had coverage and there was just nothing there. And in fact, 2 situations that I know of very well was through a rental property that one of our clients had, and there was a clear exclusion in just about every residential rental policy or homeowner's policy or general liability policy for anything to do with real estate that natural occurring mold is not covered. Well, these people thought that they had the max coverage. They did not have a balloon policy or an umbrella policy to cover the bigger events. And in fact, they were defending a personal injury claim for toxic mold in their rental home and paying an attorney $650 an hour to defend this claim. There was no insurance for it. They did not have coverage, and they did not realize until it was too late. You have to make sure that the policies that you have match the risk, right? So a lot of times what you find is people have starter policies when they started the business, and now we're at 7, 8 figures, 9 figures in business, and we have that same old policy we started a few years ago. And it's remarkable to me what the risk exposure there is, and that the business owners just don't understand. Number 9, you should be planning your exit years before you sell. Plan your exit if you can when you start the company. I know that's difficult. I know it's very interesting to talk about planning for all these things when you haven't even made money yet. There's a very famous book. I did not write it, but I have no problem promoting it. It's called Built to Sell. And the idea is you've made your company stronger if you're building it from day one to sell. Oftentimes we see our mergers and acquisitions work, people selling for the wrong reasons at the wrong time. They built this company for the kid to inherit. Well, it's been clear for the last 5 years the kid did not want to inherit that business. They're selling the business because they're having a very bad downtime, down cycle, down period. That's the worst time to sell a business because they're going to take a loss. They're selling it because they need an annuity payment, and someone told them that they could get 10x for this business 10 years ago, and it has absolutely nothing to do with the actual value of their business, and they've never really looked at what this business would sell for. And also, Talk to a business broker, talk to an investment banker, understand, what does this business look like? Is it sellable? Is it an asset that can be sold? Is it a process that can be replicated without just the sole owner or sole proprietor at the helm? This is a lot of things that law firms have difficulty doing. This is one of the things that I build every day to try to build myself out of the necessity of the practice to make sure we have something that is sellable and it's a repeatable or replicable process without me at the helm. That is a business, but you should be looking at those things from day one. Buyers are going to pay less for something that's a mess. If they have to clean up your legal mess, if they don't understand what your cap table is, if they don't understand the investors and the agreements and your vendor agreements and your employee issues, the valuation of your business is going to go down. Due diligence is when you go through a transaction and the lawyers are digging through everything. This is not when you want to learn about all the problems in your business, right? You thought you had this great thing. And I always call it like, this is your baby. This is your beautiful baby. You have so much respect for it. And the lawyers come in and they call your baby fat and ugly. How about you have a real honest conversation with your CPA? You think your CPA is great because for the past 5 years, you've shown no profit and paid no taxes. Well, that might be some great creative accounting, but at the end of the day, how valuable is your business if it's made no profit over the last 5 years? So you need to certainly look into making sure your business is structured right for a sale way before you're putting it on the sale block, and making sure that you're cleaning up your contracts, your intellectual property ownership, your corporate documents, making sure you're looking at salaries, what money and real expenses are coming back out of the company, and clean up your cap tables. What do I say by that? A lot of times we have a cap table, capitalization table, the investors that may or may not be in the company. We hear about these silent investors. We hear about profit share. Well, what does that mean? Do we actually have other owners involved in this company that we're going to have to deal with in the sale? Those are things that, if they are unknown and not rectified and not cleaned up and documented properly, are going to cause you problems come sale time. This is point number 10. I think you should be looking for someone that's acting like a business advisor, not just a document machine. I think lawyers in general are taught to be very transactional, very one-off. You ask me about A, but I'm really thinking about B, C, D, E, F, G, all these other things, because the problem that you've raised raises all these other concerns for me. And now, it's not malpractice. It's not unethical for the attorney to not sell you or tell you about all these other things. And most attorneys have these anti-solicitation rules built so far into their head that they don't bring up these other things. What I've done over the last few years, and I've been in this profession now for 26 years, is learn from the mistakes of others and myself. I am able to coach, I am able to advise from the perspective of the business owner because I am one and I understand what it looks like from your perspective. Now, I also have a certain amount of legal training that the general business owner does not, so that's a little bit of a different set of eyes. But at the end of the day, I want to be proactive, advising a client. I wish I could tell you, if you do these 3 things, you'll always be a success. That's a pretty hard one to do, and if I could do it, I probably wouldn't be making this video. I'd probably be retired sitting on a beach somewhere. But on the other side of it, I can tell you, if you do these 3 things, I've seen 99% of the time them end up in very, very bad problems. So please try to avoid those things. Please don't try to make deals with the devil because they've been in your backyard for 2 years, but you've just complained about them for a half hour about they're bad at management, they're bad with your employees, they're bad with money, and now you're talking about them taking over your company. That may sound like a joke. I've had that conversation more often than I would care to really estimate for you. So just really look at your business attorney being an advisor. I have the opportunity to sit back and look objectively and just want to protect that business. You have a lot of times when you're dealing with the C-suite, the CEO, the owners, the founders, they get the bias of making their decisions. Everyone does this, folks. If I hire a brand new employee, if I hire a chief revenue officer that's supposed to be the saving grace for my company and comes with all these high accolades and has all these connections, I'm going to want to believe he's telling me the truth because I just made that decision, and I'm going to want to ride it out for a foreseeable period of time. If I, as the business advisor, am looking at that and seeing objectively, well, the first meeting we had, he did nothing. The second meeting we had, he did nothing. He's not really progressing. He's saying a lot of things. He's moving his lips, but he's really not getting there. That's not something that the CEO is seeing necessarily that quick because he still is biased. He's still living under the assumption that he made a good hire. This is something I've done myself. This is not me taking shots at other people, but having an independent business advisor through your business attorney actually look at that, look at it objectively, and not have any of that bias and start getting in your ear like, hey, do you realize this guy is giving you the same BS answer 3 times in a row? You felt good because he's a good dude and is saying the right things and you think he's making movement. He's made none, he's brought no deals. And oh, by the way, the 2 other underperformers you have over there have been crushing it every week. And we probably need to look back in that corner to who's actually performing. So when we're doing business advisory work on the fractional general counsel side, we're not just filling in templates for you. We're getting to know your business. We're getting to know the people. We're getting to know how they operate. I joke a lot now about attorneys have many different names, attorneys, lawyers, counselors at law. And counselors at law I used to think was really a funny one, but now I really see that. I joke about that a lot more too, because I do a lot of counseling now about personalities, about how to have the conversations. Listen, I've talked to those 3 executives. If you come at them headstrong, they're probably going to balk. It's probably going to create a pretty huge problem for you. Why don't you do it like this? Why don't you maybe present it to them as a problem and see if they can help you solve it? And just go to them and say, listen, from my perspective, this situation, these things are not really working out. What do you suggest? And try to get their input, try to get their buy-in rather than the attack of this isn't working, you suck, you need to go. So certain things like that and strategic ways that I've negotiated through litigation for years. And I'm not saying I'm a mastermind and I can do this 100% of the time for everybody, but it is very helpful to have that business advisor, that trusted advisor on your side. And I find just a lot of business attorneys are not doing that. They don't have those relationships. Where we are taking this firm, Venerable Business Law, and our affiliated companies over the next couple of years will be for that concierge, for that trusted advisor, for that in your ear, part of your business advisory type services, and not just one-off documents. Through your legal consultant, your fractional general counsel, your business lawyer, whatever you want to call us, that are going to take you to that next level. The questions you should really ask when you're looking to hire a business attorney are really just pretty simple. I mean, I think go through just normal get to know you questions. And I don't mean how many children you have or whatever. Listen, if those things are important to you, by all means, understand who the person is. When you are interviewing a business attorney, I always equate it to me going to see the doctor, and my wife is a registered nurse, and when I come home and she says, did you ask the doctor these 10 things? And I said, no, sweetheart, I did my best to honestly answer the 10 questions that he asked me, but I wouldn't even know where to begin to volunteer to ask questions. I've gotten better about that over the years, and I have formed relationships with doctors. I do have several doctors that are clients, so there's that level of familiarity now. I like to say that I'm not intimidated by any man or woman, but some processes and the process itself might be intimidating to me if I don't understand it. Take time to actually understand the process. Take time to actually understand the human being that you're dealing with. Ask as many questions that you can to make you feel comfortable in doing business with this person. Just because they sit in this different position, they speak this different legalese language, just like doctors do, doesn't mean that you have to sit back and just be accepting of bad customer service and rude treatment and speaking down to you and patronizing you. I often use the phrase, and it's probably not that great to share, but I have no problem putting it on video. The big firm around a lot of lawyers, and I'm not necessarily talking about my partners or colleagues, I'm just talking about seeing high volume of attorneys and the way they interacted with the clients. So don't accept that. Yes, we have a different level of knowledge. Yes, we have a higher level of knowledge in many legal things, and that doesn't make us better than you. That doesn't make us able to patronize you. And quite frankly, let's really be honest, folks. The most business owners that we are dealing with, let me break the stereotype right now. Let me just throw this out for you. Most of those people are more successful than the lawyers. Lawyers are some of the most unsuccessful business people as a profession because they're so concentrated on doing the one thing, they're not worried about running a business. The true business advisors for you are going to help you grow a business and not just be a cost center to you. So look for that type of advisory help. Look for someone that can be in your corner when you need them. Look for someone that you can call after hours if stuff is hitting the fan, and they can pick up the call and make sure that they're giving you real legal advice and not just spouting out a different format or a different templated answers. Okay, well, there you have it, folks. So those are the 10 things that your business lawyer should be doing for you right now. So if this was useful, make sure you subscribe. Please consider subscribing. please consider sharing, liking, asking some comments, putting anything in there if you want to see more. If you realize that your lawyer is missing the things that we are talking about, feel free to book a call with us. We're happy to talk to you. We're happy to help you find another lawyer in your jurisdiction if that's the case. But we can certainly offer a free consult with my team. And there is a link to book a call with my team in the description within this video. And we can get you protected properly. That's it for now. Thanks for watching. Hopefully we'll see more soon and catch you on the next one.